Hello, and welcome to this Federal Society webinar call. Today, September 6, 2023, we're delighted to host a case preview of Acheson Hotels versus Laufer, a case considering ADA tester standing that is set to be heard by the Supreme Court next month. My name is Kayla Kleist, and I'm an Assistant Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we'll keep our introductions today brief, but if you'd like to know more about either of our guests today, you can access their impressive full bios at fedsoc.org. Today, we're fortunate to have with us as our moderator, Mr. Joel Nolet, who is an associate at Wiley Ryan LLP, where he advocates on behalf of corporate and individual clients in a broad spectrum of complex litigation matters. Prior to joining Wiley Ryan, from 2019 to 2021, Mr. Nolet clerked for the Honorable Raymond Grunder of the U.S. Court of Appeals for the Eighth Circuit, and from 2021 to 2022, he clerked for the Honorable Timothy Kelly of the U.S. District Court for the District of Columbia. Now, while there's certainly more that could be said, for now, I'll leave it there, and I'll leave it to him to introduce our other speaker for the day. A last note for our audience before I get off your screens: if you have any questions throughout the program, please submit them via the question and answer feature, likely found at the bottom of your Zoom screens, so that our speakers will have access to them when we get to that portion of today's webinar. With that, thank you all for being with us today. Mr. Nolet, the floor is yours.
Thank you so much for that kind of introduction, Kayla. It is my pleasure today to be able to moderate this discussion featuring Karen Harned, whose resume speaks for itself, and I will just cover the highlights. As Kayla said, the full CV is available at the Federal Society website. But Karen Harned is president at Harned Strategies LLC. Previously, she served as the executive director at the National Federation of Independent Business, their Small Business Legal Center, a post which she held from 2002 to 2022. Prior to joining the legal center there, Ms. Harned was an attorney at a Washington, D.C. law firm specializing in food and drug law, where she represented several small and large businesses and their respective trade associations before Congress and federal agencies. Ms. Harned, thank you so much for taking the time to be with us today.
Thanks so much for hosting me, Joel.
Yeah, our pleasure. Well, just to kick us off, we're obviously talking about Acheson Hotels versus Laufer, and going to be exploring tester standing, as well as maybe the bigger issue lurking in the background that arises under Article 2 and the very interesting amicus brief that you all filed in this case. But just to get us started, if you could please set the table in what's the statutory and regulatory background in which this case arises under.
Right. So everybody, I would hope, is familiar with the Americans with Disabilities Act. And a lot of focus typically is on Title II, which deals with, people with disabilities in the workplace. But this case concerns Title III. And under that statute, every business or place of public accommodation is supposed to ensure that their business is accessible to the disabled. And so, there's been a lot and it needs to be readily achievable, not unduly burdensome. That's been a lot of where you've seen the litigation over the years, especially when you're talking about, historic buildings or older buildings, because those buildings typically do not have to do anything major until they do any sort of renovation, but any sort of renovation is going to put them in a category where they're going to have to meet certain parameters. And so the bottom line is all disabled persons should be having equal access to public accommodations, just like, those of us that are not impaired. And so that is the backdrop of this particular case. The other issue, I guess I should say, with regards to this one is there is a regulatory requirement that falls from the statute with regards to places of lodging, which this deals with, because that's Acheson Hotels is obviously a hotel. And that is called the reservation rule. And it basically says that any person, that's disabled should have equal access to, the ability to make reservations and also to learn what accessibility amenities are at that hotel prior to, showing up there and finding out that, they don't have what they need for their particular disability. So that rule is also in play here, and it's called the reservation rule.
Fantastic. Thanks so much. So with that in mind, that brings us to the parties in this case, as you already alluded to briefly. Could you tell us a little bit about Ms. Laufer on the one hand, the plaintiff in the district court proceedings, and then Acheson Hotels on the other hand?
Right. So Deborah Laufer is, not surprisingly, a disabled American, and she can't walk more than a few steps without assistance. She needs to use a wheelchair or cane to move around. She also has limited use for hands and is visually impaired. And so she needs special accessible parking, has to use passageways wide enough for her wheelchair, things like that. Sloping requirements are important for her when she's trying to get in and out of a place. And then Acheson Hotels operates the Coast Village Inn and cottages at a small town in Maine's southern coast. And it gets reservations both on its website, but also through third-party platforms like Expedia and the others. And so that's that with regards to who they are. Do you want me to get into the facts of the case?
Please, yeah. So
Sure.
we have a Florida resident, a Maine hotel.
Yes.
How did we get here in this case?
Right. So this case does concern what is called an ADA tester plaintiffs, and Ms. Laufer is proudly one of those. A tester plaintiff is someone that really sees it as their job to help enforce the Americans with Disabilities Act. And I apologize because I should have, in the setting of the table, noted that the enforcement of the Americans with Disabilities Act does not just fall on the Department of Justice. It falls also on individuals. So it has a private right of action. And indeed, this statute, I would say, is primarily, at least the Title III, I can't speak to Title II, but primarily enforced by individuals and like Ms. Acheson. And so these tester plaintiffs really look at as their job, as their mission to ensure that every business is complying with the ADA. And so what she did in this case is she'll go around, and she says that she's done this. In fact, she's filed 600 lawsuits under her name over the years. And she will look on the websites and see, is this particular hotel telling me whether or not they have the, the accessibility are they meeting the accessibility requirements I'm going to need? Are they giving me that information that's required under this reservation rule? In addition, she'll look to see if the third-party platforms, if they are also ones that will support booking the certain establishment she says she wants to go to, are they meeting those requirements? And so she literally, as the plaintiff in the case, or I'm sorry, the petitioner in the case says, is sitting at her home in Florida, looking at all these different websites to see if they're ADA compliant, basically.
Okay, so she's doing that. She's sort of exercising her role as a ADA tester, self-identified and proud to be an ADA tester, and so she's sitting at home in Florida, and she gets on the Acheson Hotels website and discovers that it doesn't have the information, at least allegedly, it doesn't have the information that the reservation rule requires. So if you could then pick up the thread what happens next? She sues in the district court, and things go from there.
Right. So she sues in the district court, and Acheson Hotels immediately files, a motion to dismiss, saying, among other things, that she has no intention of ever going to this facility, this inn. And so therefore she does not have a real injury, a concrete injury that, would allow for this lawsuit to continue. So it really was a question of standing from the beginning in the district court. And so the district court, and it is not in question that she had no intention of going to the Village Inn or whatever it's called. Sorry, I'm so bad. But anyway, Village Inn, the Coast Village Inn, that she had no intention of going there. that's not in question. That's not in doubt. So that's, I think, important as we're looking at this case moving forward, especially to the Supreme Court eventually. So the district court agreed with Acheson, straightforward, you're right, no particularized injury. They go up to the First Circuit Court of Appeals, and there that court takes a completely different position, relying on a case called Havens Realty. They say that, yes, this is actually an injury because, basically in the same vein as the Havens case, she was, as a disabled person, injured because she didn't get the information she should have received. They do the First Circuit does really square this up with this case Havens Realty, which I'm going to go into now, and there's a real question as to whether or not those facts do pan out as far as being completely analogous. But in Havens Realty, that concerned the Fair Housing Act of 1968, and it concerned a Black American who had tried who had gone on multiple occasions to a property asking, do they have any, openings for them to rent, a place there? And each time, unfortunately, this person was told no, although then a white quote unquote tester would come in, ask the same question, and be rented a place. And so they did find standing there, they did find injury there because the injury in that case was misinformation, right? Because when that Black American went in to ask for a residence, they lied and they said, no, we don't have anything. And they knew it was a lie because they proved it up when they had a white tester go in. And so in this instance, she's trying to say, under this reservation rule, Ms. Laufer is trying to say under this reservation rule that it's the same thing. We are allowed information, on the website as to whether or not there's accessibility, what the accessibility accommodations are for whatever place. And also we're allowed it on the third party websites. And if they don't have it straight up, we're injured. But as I hope a lot of our listeners have remember, just 2 years ago, I think, the Supreme Court in a case called TransUnion said it was not enough to just have a statutory violation. That's not your key to the courtroom, right? That you had to have a concrete, particularized injury. And so just saying, hey, I can check this box that this statute, is somebody violated the statute, even though I wasn't harmed. In that case, that dealt with credit reporting, and these people did not have any bad outcomes as a result of some mess ups with their credit reporting. But the statute was violated technically. And so the court said, no, that's not enough. You're going to have to show that there's real hurt and real cause of injury here. And so that is really what is set up in this case. What is her injury? And is it enough to get her, Article 3 standing as a tester plaintiff?
Yeah. So, just to recap before we get to the Supreme Court proceedings, where we're at now. So the critical issue that's been percolating both at the district court and in the First Circuit was the injury in fact prong of the standing analysis, which arises under the Article 3 case or controversy requirement. Without meaning this word in any pejorative sense, but it's a gloss on the case or controversy requirement. It's three criteria that the Supreme Court has interpreted as consisting of a case or controversy. You identified two cases, Havens Realty and TransUnion, and you mentioned the dates of those cases. I suppose one interesting thing too is that Havens Realty comes in the 1980s, which in a way precedes the sort of paradigmatic formulation of Article 3 standing in Lujan versus Defenders of Wildlife, which was a decision in the early 90s, where Justice Scalia, for the majority, sort of synthesized all these various threads of jurisprudence that the Supreme Court had developed up to that point in time into these three criteria. The key one for our purposes being the injury in fact requirement. And then we have the TransUnion case following that, right, which if I remember correctly, one of the key lines was an injury in law is not an injury in fact.
Correct.
And it's an injury in fact requirement. So the TransUnion case spoke of the need for downstream consequences of a bare statutory violation. You can't just have a bare statutory violation. There had to be some real world effect.
Mm-hmm.
So the jurisprudence may be maybe a bit unsettled,
Right.
for lack of a better word. So one last sort of table setting thing before we get to the merits, if you will, of the threshold standing issues before the Supreme Court. Which is there have been some interesting post certiorari developments, in particular with plaintiffs' counsel. Could you tell us a bit about what's going on there?
Correct. So actually, one of the attorneys that has represented Laufer in the past, but not in this particular case, has recently been sanctioned by the Maryland Bar Court because they are basically a vexatious litigant. They've been bringing, as I mentioned, 600 of these cases. And so as a result, they are not allowed to do this anymore. And in this space, I should say, that is not the first attorney to be called out. We've seen that happen in a number of occasions in California. This case, as a lot of the amicus briefs will indicate, there has, with regards to the ADA and the private enforcement mechanism that is used there, you have seen a cottage industry that has developed over the decades of attorneys that are literally just doing the box check, have no intention of visiting the business, but, as a tester plaintiff or even as whatever, just an attorney trying to make money, trying to get settlements, you see them filing these lawsuits. And so in a number of instances, you have seen courts come back and call out the vexatious litigant and say, no, you can no longer file any of these cases. I say, he did not represent her in this instance, though I guess her attorney may have some relationship with this person. But her view was it still needs to be mooted out because she really didn't want the distraction of this whole vexatious litigant issue that's in the background. And that's not surprising because she wants to be able to continue to do this and is worried that's like not the best backdrop for, that this court is bad facts in her mind would make bad law, right? Like she doesn't want the court to see how it's been used, even though honestly, that is, I think, part of the record now anyway.
Yeah. Right. There's been change of forces midstream of sorts, right, between the cert brief, the cert stage with plaintiff's counsel, and then the merit stage. And I believe she's now represented by folks at Georgetown Law and a clinic at Georgetown Law. So they have, in addition to filing an opposition brief on the merits, they have filed it's captioned a suggestion of mootness. Can you just tell us a little bit about what happened there?
Oh yeah. So I apologize. Oh my gosh, I apologize, Joel. Also because, yes, I apologize. I'm getting this confused with something else. Yes. So the suggestion of muteness is she asked for her case to be dismissed. And so she says it's no longer, a viable case. But Acheson Hotels has said, look, we need this case decided because of the reasons I just noted, which is this has been going on for a while. We've seen a cottage industry develop. And quite frankly, there is a big circuit split on how these cases have been resolved as to whether or not there is standing in these tester cases. So if they don't take this case, they're going to have to take one because really, honestly, the Supreme Court's the only ones that are going to be able to decide it. So that is Acheson's argument. And so the Supreme Court said, look, we're not going to moot it right now, but they are going to hear argument. When they hear arguments in the case on October 4th, they're going to discuss it at that time.
Yeah. It's certainly a curious development.
Yeah.
Ordinarily, if Ms. Laufer went ahead and actually dismissed her case in the district court, and of course, mootness goes to a federal court's Article 3 jurisdiction,
Right.
and so ordinarily, when a case becomes moot, especially if it's on appeal, the solution is to vacate the decision below and remand with instruction to dismiss or what have you. The curious, particularly curious thing in this case in particular is that, of course, the issue is standing, which is also a jurisdictional question, and courts have discretion. There is no necessary ordering of sort of jurisdictional issues when a court is presented with multiple ones. And so, if the court decides to resolve the case on standing grounds, it doesn't have to reach mootness, and vice versa. So, in this instance, the Supreme Court has the discretion if it wants to adjudicate the standing question, because at the end of the day, all it's ruling on is the scope of subject matter jurisdiction over this action.
Right.
Now, there's one more mootness wrinkle, which comes from the other side, and could be in potentially an alternative grounds of decision if the court decides not to reach the standing question. Could you tell us a bit about Acheson Hotels' mootness argument in this case?
Correct. Yeah. So then, although they say they want it decided, they also have said that there might be a mootness issue on their side because they took care of the problem. They now have this information on their website. As we'll see in the arguments, though, it's still not on all the websites on the third-party platforms, but it is on the Coast Village Inn's website now.
Right. So, okay. So with all that on the table, and I feel like the table very well set, and some potential hurdles that could get in the way of what I'll maybe inaptly call a determination on the merits. In reality, of course, the merits here is a standing question, and not a true merits question. But so the issue before the Supreme Court now involves Article 3 standing, and particularly the injury in fact requirement of Article 3 standing. As you mentioned earlier, one thing that is now clearly established is that Ms. Laufer has no intention of visiting the Coast Village Inn. So she is claiming injury more or less purely in her capacity as an ADA tester. Right. So could you, maybe it makes sense, although of course Acheson Hotels is the petitioner, and so they're challenging the First Circuit's determination that Ms. Laufer had standing. Maybe if you could sketch out for us Ms. Laufer's position as to why she has standing, and then explain Acheson Hotels' counter arguments to her case for standing.
Right. Well, she says that she has standing. And honestly, one of her first arguments isn't really as prominent, if at all, in the Supreme Court. But originally, she said, with the reservation rule, that's a straight up. She's required to be able to have this information, and the information is whether or not it's accessible. That box was not checked when she went, on the website. So that's one injury. She also argues that it's, particularized to her because she's disabled. She's a member of the disabled community. And even though she wasn't going to visit the inn, because she is a disabled person, the law is for disabled people, it still is particularized to her. And she also argues that there's, going to be a stigmatism for her every time she goes to this website and sees that they are not honoring her and not treating her equally like they would treat other people that are not disabled. And so all of that is meant to, of course, prove that she's feeling a particularized concrete injury. So Acheson really says, no, that is not how this works. That ADA is not a backward-looking statute. It's forward-looking, and you have to look at what's actually going to happen here and what's actually going to happen to the person. And the fact that she didn't receive information on, the accessibility of the hotel is irrelevant, right? Because she had no intention of going there. So there can't be a harm if you're letting, it was non-useful information. It was information that was not ever going to be useful to her. So that that doesn't work. So the informational injury does not work to her. And it's not particularized because she's not personally harmed by it. She again has said, and it's on record, that she wasn't going to attend or go there. So she was not going to be harmed in that manner. Let's see. She also, they do say, I think they're making the case that TransUnion, would govern here over Havens Realty. But they say, even if you're going to put that aside and go with Havens Realty, this is different because that Havens is distinguishable because the plaintiff in that case relied on a federal statute that personally entitled that person to information and granted her a private cause of action to vindicate that right. But Laufer's, it's a federal regulation. It doesn't entitle her to information on a federal statute that does not, and personally entitle her to information on a federal statute that does not grant her a cause of action to vindicate that right. Like that, it was just, so bottom line is, with regards to, and also on the emotional side, that person was, you can make the argument probably for stigmatism more in the Havens than you could under Miss Laufer or Miss Laufer's argument, because that person knew they were being lied to and knew, in this instance, it was a one and done, and it really was never going to matter to her because she was never going to go. I mean, that's really, I think, the bottom line of Acheson's point here. And it's really the point on the tester plaintiffs generally is they're just out to, they're never going to, they're out to, get what TransUnion says you can't, like a violation of law, but not really of anything that's, personally going to injure them, impact them in a meaningful way. And I think that's just the bottom line of what they would argue there. They also do note that, there is a question as to, well, I guess that's, I'll leave it at that.
Sure. And I suppose, complicating matters somewhat, it would be really clean if Havens Realty was decided in the 80s and Lujan came in the early 90s and the law has gone in a different direction. It would be maybe a bit more straightforward to argue that Havens Realty is sort of moribund and should just be expressly overruled, but has been de facto abandoned. Of course, complicating things, as Ms. Laufer points out, is that in TransUnion, the TransUnion court cited to Havens Realty as a sort of an exemplary case where Congress has the ability to sort of elevate de facto harms into legally cognizable claims in federal court. They can say, like, okay, even if you couldn't ordinarily sue for discrimination at common law, although you could in some instances, parties get into that in their merits briefs. But even if you couldn't, Congress is certainly free to make discrimination actionable by statute. And so, I suppose it'd be fair to say that there's a bit of a tension where TransUnion is simultaneously citing to the Havens Realty and the principle that comes from Havens Realty. While also, certainly as Acheson Hotels is arguing, seems to really be undercutting, at least some of what Havens Realty has been cited for with respect to what is a sufficient injury in fact.
Right. And I should note, as somebody that's been dealing with this for a number of years, because as you noted in my background, I've represented small businesses, and honestly, they have been some of the biggest targets. In fact, this Coastal Village Inn, I'm suspecting, is a small business. They have been targeted a lot by these lawsuits over the years by these tester plaintiffs. And when the TransUnion case came out, in fact, NFIB's legal center, which I ran. Oh, sorry. Oh my goodness. Okay. I apologize for that. Anyway, when TransUnion, we at NFIB, we filed a brief on, this whole issue because with these ADA tester suits in mind. And so when that decision issued, we really saw it as, oh my, this is going to really be a good thing when it comes to these ADA tester suits. So it's so funny that this is now all coming to the fore now.
Yeah, for sure. Okay. So I feel like we've sort of surveyed the Article 3 landscape and the core question before the court. And it really is, as you said, it's going to be this question of stigmatic injury. That is Ms. Laufer in her opposition merits brief before the Supreme Court has really leaned heavily on having a stigmatic injury in the same vein as that tester plaintiff in Havens Realty who was discriminated against by being lied to about availability of housing based on her race. So that's all under Article 3, and that is the central question that is going to be before the court if it does in fact get to the standing question. That said, you all have filed a very interesting amicus brief, which is looking at these issues really on a different axis, if I could put it that way, where and certainly a thread of Article 3 jurisprudence. One of the principles that the court has leaned on when it has, in glossing the case or controversy requirement and articulating these 3 criteria of standing, including injury in fact, is separation of powers. There is a concern that if unharmed plaintiffs are just given the right to get into court simply by virtue of the existence of a statutory violation, that would interfere with the executive branch's ability to take care that the law is faithfully executed, which Article 2, of course, commits to the executive branch. And your amicus brief explores this. Could you please go into detail and tell us about your arguments in the amicus brief?
Correct. So I, as one of my positions is I'm executive director of what's called the Center for Constitutional Responsibility. And one of our real concerns is separation of powers when it comes to enforcement with regards to, these new, more and more, it seems like there are statutorily created private rights of action for us as citizens to basically do the government's job and enforce the statutes. ADA is a prime example of this. Clean Water Act and Clean Air Act actually also have those private rights of action that people have used over the years to enforce those laws. And so our argument is that we think there is a real constitutional problem with these, that this is a separation of powers issue, because whether it's in this case with her standing or under Article 3, but even also under Article 2, you're now losing the Constitution requires that the executive is the one that is supposed to enforce our nation's laws, full stop. And that the executive is the president and his legal officers. It is, and in the states, the governor and their, legal officers. And by letting the citizens do it, you're losing a lot of things. You're losing political accountability. You're losing, because just anybody can go and sue to enforce, and nobody really has a way of stopping that, right? Like if they don't like what's happening, you can vote somebody out, but you can't vote away a lawsuit. And similarly, or I don't know if it's similarly, but another argument is that it's just an unconstitutional delegation, that the executive is the one that should be enforcing our nation's laws, and it should not be up to the citizens. And so that is the case that we make in that brief, because there has been some activity and there's been some thoughts from the court we've seen as recently as just last year or last term, the Plinsky decision, where there does seem to be some openness to looking at whether or not some of these private rights of action, in that case that dealt with the Medicare fraud statutes that allow for relators to go in and sue on behalf of the government for violations, whether or not that's, meets the separation of powers principles by delegating out that enforcement authority to private citizens. So that is the case we make in our brief, and it'll be interesting to see if the court bites, on that one. Obviously, I hope they do, and at least reference it some more, but we will see.
Yeah, I would say, in the merits briefing, and I should have mentioned previously, but the government also has filed an amicus brief and is actually seeking some argument time, given kind of to the point of your amicus brief. The Attorney General's very prominent role in enforcing the ADA. The Attorney General has been delegated authority to promulgate regulations to implement the ADA, and it brings enforcement actions. But yeah, of course, that is. As the government points out, that is significantly complemented through private litigants and private lawsuits brought under the ADA. But yeah, so the government has submitted a brief arguing for basically agreeing with Acheson Hotels that the court should find no standing here, but asking for a much narrower holding and disagreeing with some of Acheson Hotels' more broader arguments that would certainly change the law a lot more, or at least develop the law a lot more than I think the government currently clearly, based on its brief, would like to see. The one thing the government does point out in its brief is that this. They do in fact respond to this. Let me just put it that way, and they drop a footnote, sort of flagging the Article 2 concerns because it's raised in Acheson Hotels' merits brief, and they argue that these separation of powers considerations should be taken into account in the standing analysis. Well, all that's fantastic, and thank you so much, Karen, for that. All that information. Just briefly on this, to note and to invite your thoughts and comments before we turn to questions. But the doctrine of standing has had an interesting life as of late, where I think it's fair to say that some of the Supreme Court decisions have created strange bedfellows. I think of the TransUnion case, which Justice Kavanaugh, if I'm recalling correctly, wrote the opinion for the court and was joined by 4 other justices, and Justice Thomas wrote the dissent. And he was joined by, I suppose, what is typically considered the liberal wing, if you will, whereas Justice Kavanaugh was joined by the so-called conservative wing of the court. And Justice Thomas has taken the position that the current standing doctrine is unoriginalist, and it has gotten away from what the case or controversy requirement actually requires within the original public meaning of Article 3. All that said, you mentioned the Polanski case, and it was Justice Thomas in dissent in the Polanski case, who that involved the key tam provisions of the False Claims Act, or at least his dissent did, and he sort of indicated that he believed the key tam provisions of the False Claims Act violate Article 2. For the very reasons that you're sketching out, that it deputizes to private citizens the ability to enforce the law when that is kind of presumptively and exclusively the executive branch's prerogative. And I believe Justice Kavanaugh and Justice Barrett
they also suggested that it was ripe for review. So that is why another reason why we're hopeful that our brief will, resonate on that grounds. In this particular case. And yes, you're right. I'm sorry. I forgot to mention that was a critical part of the plaintiff's, or I'm sorry, petitioner's briefing here. And one of the things they said, which I did not note in the reasons why this is a problem having the private plaintiffs, is you don't get prosecutorial discretion. It's just, catch as catch can. It's everybody's out for themselves. And that's really also not very helpful when you're trying to enforce a law. It doesn't give predictability, for one, as far in there, just again, accountability and other issues surround that.
Yeah. So this is a very interesting issue, and I'll just also add, I feel like Judge Newsom, of course, a number of folks have been discussing this and exploring this, but I feel like Judge Newsom on the 11th Circuit has played an outsized role in a 2019 decision, the Sierra case, I believe, and then more recently in a case involving Ms. Laufer. I think it was Laufer versus Arpin LLC. That was in the 11th Circuit, which has since been mooted. But Judge Newsom wrote 2 concurring opinions that have really sketched out certainly his thinking on the Article 2 problems with deputizing private litigants to sort of enforce the law in the way that testers, more or less do.
Right. Absolutely. No, it's good. And I'm glad, just as from a policy perspective too, again, as somebody that's a small business advocate, that this is finally coming to the fore, because I really do think that there needs to be some parameters put on this. I mean, I'm obviously showing my bias, but it really has become, you just see it more and more where different groups are able to use a statute to make a cottage industry out of enforcement. And I'm not sure that's to Newsom and others concern like that. I'm pretty sure that's not what our founders had in mind when they created our justice system. So
great. Well, thank you again so much for sharing your thoughts and insights and the sort of very interesting angle that seems to be an emerging issue that you all are fleshing out in your amicus brief in this case. Before we turn to questions, I'd like to give you an opportunity for any final thoughts about the case or anything that hasn't been said quite yet.
I think we've covered pretty much most of it. I would just say I really am hopeful that the court doesn't kick this on mootness, because they're going to have to answer this question. This is a very live issue. I can't remember how many different courts have already ruled on this, but the splits are significant. It's at least 3 circuits, I think. And so they're going to have to do it sometimes. So since they've taken the case, I'm hopeful they will, in this instance, go ahead and say what the law is here on tester plaintiffs.
Yeah. Time will certainly tell. That's a great segue. In fact, a number of folks have asked questions just about this. The curiosity of mootness being an issue in a case involving standing, where the court, again, the court has discretion to decide which of those subject matter jurisdictional doctrines it decides to address. But a few folks have asked, more or less, wouldn't it be strange for the court to essentially, again, pass on the merits of the standing question if the case is in fact moot. So, which you've more or less just answered. But what I don't want to put you on the spot to make a prediction, but why would the court just not kick the case on grounds?
Oh, on standing grounds?
On mootness grounds and not
mootness grounds. Sorry. Yeah. No. Well, I mean, I think there are a lot of reasons why they would, and so maybe they would make new mootness doctrine, through this, or say, or I don't know, or just, I don't know, what's the word, bolster what's already out there when it comes to mootness. But I guess what we have seen recently is they are not shy to kind of color outside the lines on some of this stuff. I mean, just last year in the West Virginia versus EPA case, that they issued a ruling on a rule that wasn't even in effect, right? And many of us like that outcome, but that was an interesting posture there. And so this wouldn't be the first time that they've, this ended up being the vehicle, and they're going to go ahead and bite the bullet. Like I said, on this one, I actually think there are grounds for them to, justifiable grounds for them to go ahead and just decide it, because if not this case, it's going to be another one. They've already accepted it. They've already done all the reading on it. The arguments on the tester issue are fully presented, I would argue. And so why not just go ahead and do it? But it is very interesting that when they were asked to moot it out, they declined to do so. And so that actually signals to me that they want to go ahead and just get this resolved.
Yeah. The good news is that we might have long to wait, I suppose, but at least we'll have some inclinations. Oral argument is scheduled for October 4th, so there should at least be some more tea leaves to start reading beyond the one that you've already mentioned, which is them deciding to take mootness up with the merits of the standing issue, as opposed to just resolving the case on that grounds. We have one one question in the queue here that maybe if you just want to if I can invite you to riff for a little bit, but there are certainly many private causes of action in the law, both state and federal, and of course a number of state governments follow the federal separation of powers principles. They have a tripartite scheme, and the executive branch is tasked with law enforcement responsibility. What would if the court does, whether in this case or the next case, with this as maybe a jumping off point. What are some of the ramifications that you could see from the court? Let's say it develops an Article 2 jurisprudence along the lines that your amicus brief argues for. Mm-hmm. What would be some of the ramifications and maybe some of the limiting principles? Where would plaintiffs not be affected versus where would the plaintiffs currently be affected if the court started to conceptualize things as Article 2 rather than Article 3 questions?
Right. Well, I definitely think look, if they went as far as we would suggest, then, you have a non-delegation problem, and you're not going to be able, for example, citizen suits that are filed under the Clean Water Act or the Clean Air Act would no longer be able to go forward under the Americans with Disabilities Act. I think I think the issue is, if you're harmed, right? Like, I don't think that this would knock out every ADA lawsuit, but I do think it would knock out lawsuits where somebody is not harmed, as in the tester plaintiffs in this instance. And so, depending on how they framed it, I think the issue really should be the only time a private citizen should have the ability to go into court, and this is Karen's view of the world, is if they do have a particularized injury that is unique to them and is concrete. I mean, just as in the TransUnion case says, and that no longer will the government, it isn't surprising really that the federal government was cheering on ADA lawsuits, because that, I've even heard that from state attorneys generals when, for example, as data privacy has been considered and whether or not there be a private right of action there. Oh, well, we need the enforcement help. Well, I think the bottom line is if private rights of action as for the public welfare, for the public good, just to and help the government enforce the statute, if that went away, I just think we'd have more accountability. We'd see, I don't know, you would see less litigation as a result, but I think that's a good thing, because I think more and more as Congress is enacting, and you are seeing regulation through the courts, through these private rights of action. You are seeing the citizens taking it up and doing what Congress doesn't. And instead, what needs to happen is it needs to go back, and Congress needs to enforce. Congress needs to make the laws, or Congress needs to make the laws, and the executive needs to enforce them. And in that way, we have true political accountability. So I do think you would have a lot less litigation, but I think that would be a good thing, because it would be more accountable. Priorities would have to be followed when it came to enforcement. Because right now, honestly, I feel like with a lot of these statutes, it's the wild, wild west, and they're really used more to shake down a lot of people than to actually get good done. I mean, I'm not saying every instance of this kind of litigation is bad, but I would say most of it is, because from my experience, especially in the ADA space with small business owners, it's all about getting them to settle. They don't want to have a lawsuit. They just want to get the payout. And that is sad. And, in California on the ADA side too, sorry, but I've lived this for a while, you now see a lot of, minority business owners in particular are, have these Title III ADA lawsuits brought against them, because, the attorneys think it's going to be an easier chance for them to get a win. So I don't know. Bottom line, I just think it will make a more constitutional original structure that the founders envisioned. If we just have the executives enforcing the laws, we all as the electors can say, you need to do more on Clean Water Act. You need to do more on Clean Air Act. You need to do more on ADA. We don't need to be doing it ourselves and just going out after our personal, vendettas. I also personally think that just makes society, a lot less civil. And I don't think we need any more of that. But that's basically my take on it.
Got it. So would it be fair to say, just to recap again, sounds like if I could put it the way you did in Karen's view of the world, folks would be unaffected would be private litigants with private injuries. Somebody who they themselves were, let's just take the ADA, they themselves were prevented from having full enjoyment of a place of public accommodation in the same way that a non-disabled person would be. They would be unaffected. Where things would start being affected is those who are trying to bring lawsuits where it's the benefit maybe strictly accrues to the public or primarily accrues to the public, and I suppose you might have some line drawing problems to hash out if the jurisprudence were to go this way, but it's somebody suing because the Mississippi River needs to be cleaned up, but they live in California and they never go to the Mississippi River and they just are worried about pollution in the Mississippi River. It would be that sort of lawsuit that becomes problematic under an Article 2 framework.
Correct.
In the view of the world.
Yeah, I mean, again, if it's a particularized injury that is actually happening to you, that's one thing. But it's this roving attorney general where we're all deputized to run around and enforce the laws. That there are sadly more and more of those lawsuits, and I think they're problematic, and I constitutionally suspect, and I would love to see the Supreme Court weigh in on that.
Fantastic. Well, very good. Karen, any parting thoughts before we wrap up? I do see our time is running short here.
Yeah, no, this has been great. It's been great with you, Joel, and thank you for your wonderful observations. And it'll just, this is an interesting case. It'll be interesting to see if we get a real quick, okay, it's by, or if we get an answer to the question here on standing. So only time will tell.
That's right. Karen Hart, again, thank you so much for taking the time to lend your expertise and shed some insight on this interesting case. A fascinating Article 3 case with Article 2 kind of looming, and I dare say looming large in the background. Again, the oral argument will be October 4th, and then we'll see sometime between then and late June, early July. We should have hopefully some answers on the direction which the law is going to go here. All right. But with that,
I'll wrap it out. Thank you both so much. Really appreciate it. And you joining us today to share your time and expertise. Thank you also to our audience for joining and participating. We welcome listener feedback at info@fed-soc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events, like another webinar happening in just a half hour, I think, which will be a case preview of Harrington versus Purdue Pharma. With that, thank you all for joining us today. We are adjourned.